This is the current federal tax developments for the week of March 18th, 2024. Current federal tax developments are brought to you by Kaplan Financial Education and by your state society of CPAs. Med Zollers, we're going to take a look at some of the interesting tax developments that's come up over the past week as we're here in the tax season. First, we're going to cover what is not exactly unexpected, but it formally happened, that FinCEN gave formal notice of appealing the Alabama Corporate Transparency Act beneficial ownership information case that found that Congress overstepped their bounds constitutionally when they enacted that law. The case is going to be heard by the 11th Circuit per FinCEN's notice to the district court. We also had the IRS issue a news release reminding us that a deadline is rapidly approaching for any employer wishing to enter the first, and I assume there will be others, but this should be the most generous employee retention tax credit voluntary disclosure program. So we'll talk about that deadline coming up the end of this week. We're also going to talk about a letter written by 3 Arizona lawmakers to the IRS about the tax status of 2023 state rebates paid. And this could have an impact beyond Arizona. We'll talk a little bit about the issues involved and what the IRS told the states that enacted such programs in 23 as opposed to what those that enacted them in 22 were told, as well as the complaints. And this letter's of interest to some extent because one of the signatories on the letter is a member of the House Ways and Means Committee, who is actually chair of the subcommittee on oversight of the IRS for the Ways and Means Committee. So that's somebody who the IRS probably doesn't want to, ignore too quickly. So we'll see how everything works out there. Finally, we'll talk about the Second Circuit Court of Appeals decision that found that it is barred from a hearing an appeal of a tax court dismissal of a taxpayer's small tax case, where the court claimed that they had filed their petition too late, past the 90 days. And it's an interesting discussion both about why, some of the quirks of the small tax case situations, and then also the more interesting problem of how the Second Circuit got around dealing with the decision in the Third Circuit in the Culp case, which suggests that the tax court's position, which it relied upon in this case, that the 90-day deadline is jurisdictional and there is no option for equitable relief, how the Second Circuit just nicely walked around having to ever mention whether or not they agreed that the tax court's position on this is not supported by the law, which I found to be interesting. Okay, let's start out talking about the FinCEN appeal. In the Alabama case, this is an notice of appeal of the case of National Small Business United et al. Versus Yellen et al. This is from the U.S. District Court, Northern District of Alabama. And this notice was filed with the court on March the 11th, 2024. Now, as we all expected, FinCEN filed a formal notice that they're going to appeal the decision. As you may remember, the court in Alabama ruled that Congress had exceeded its powers outlined in the Constitution when it enacted the provisions of the Corporate Transparency Act back in 2021. Specifically, the court found that this was outside any of the theories the federal government had offered to support Congress's right to enact this, including that it impacted foreign policy, that it was a legitimate Commerce Clause, exercise of power, and that sort of background. So, the court rejected that and found essentially that Congress overstepped their bounds here, making the law unconstitutional. Now, it is a weird decision in who it applies to. It effectively applies only to taxpayers who are members of the National Association of Small Businesses, which is what National Small Business United is doing business as, and the one external plaintiff that was part of the case. Now, whether it could be expanded to cover more is an interesting question. The FinCEN has made it very clear they are not going to accept any claims by others that it covers them. So they're going to proceed with enforcement actions against others, no matter what happens with this case at this point. unless we have some other changes, which we could have at least the 11th Circuit with regard to this. Now, the other interesting thing is a new case is brought up now, apparently. There was a story written this week about the fact that they're changing some of the rules of federal rules for the courts. Apparently, now this was being pushed mainly due to concern about venue shopping for patent cases, where certain entities that some people feel were being formed solely to buy up patents that essentially from failed groups, and then try to find some way to argue that a very successful company was effectively infringing upon that patent. They would get this big, they'd have a bunch of patents and they'd just try to figure out some way that somebody with big pockets was infringing, and they would tend to file their cases always in a particular district court in Texas. That is now going to change, apparently, at least a little bit for some of these. Now, the bigger one that's going to be is when part of these rule changes would impact if somebody filed a petition in a district court and they were looking to get a nationwide ban on some federal government action. Now the law is going to say you still can do that, but instead of your case being heard by a judge in the district in which you filed, and there are some one-judge districts where you know which judge is going to get the case. And of course, if you have choice, you can find some way to get in the venues. You're going to look at the one-judge districts and then try to find the ones who you believe who are more likely to rule in your favor and file there. Apparently, the theory now is that we're going to be choosing from among a pool from all the judges in the circuit, all the district court judges in the circuit, to hear the case if you want to get a nationwide ban. If you just want to limit relief to the plaintiff, which is what happened here, then no problem. You can go ahead and just have your case heard in your district. That's not a problem. So we'll see what that does, but it means that anybody filing a new action at this point would not be able to go nationwide. There are, I've been told, a couple of other actions going in this area. Whether they actually go anywhere now that this one's moving, I'm not sure, but there are a couple of others. So especially if the 11th Circuit comes down, we may find, let's say the 11th Circuit says, no, it's fine, don't worry about it. You may find that we then get a case coming up in another circuit, somebody looking for a no, it doesn't work, and who may be asking for nationwide relief. Now, this appeal, as I mentioned, will be heard by the 11th Circuit Court of Appeals in Atlanta. They'll be the ones hearing the case here. They will rule on whether or not, whatever FinCEN is appealing that is in error about the judge's order, which is basically that the law is unconstitutional. They will rule on that. We may also have them, FinCEN may ask for a stay of the decision pending an appeal. Now, it's an interesting issue if it comes up, because generally they'd have to show two things to get a stay. You have to show that, number one, there would be some horrible damage that would occur, if in fact you are barred from, we barred from enforcing this, barred from doing this during the pendency of the appeal. And number two, that there is a reasonable expectation that you, FinCEN, will ultimately prevail. Now, they could lose on either one of those counts. The court could find that they're not going to worry about it, maybe a reasonable expectation of winning, but there wouldn't be this enough harm to justify a stay. Flip side is they may say there could be enough harm in the stay, but that they don't see that there is an expectation of winning. So it's an interesting situation to go. Might give us some clue if the court, how the court rules on granting a stay if they ask for it. But so far, we're still waiting to see what they're going to do. So we don't have that at the moment being part of what's going on. How fast is this case likely to move? That's open to question. It's going to take some time. We know they're not going to have a hearing on this week. We're not going to have a decision come down the following week. So I do expect we'll be well through this year by the time we actually get a decision from the 11th Circuit. And probably regardless of which way that decision goes, the losing party will at least attempt to get the Supreme Court to hear the case. And that would almost certainly, since we just had, as I recall, the final oral arguments, unless the court decides to take special action, basically the case then therefore wouldn't be heard until the next term of the court, which would start in October of this year, but would then go on, and would probably have a decision released in June of 25 in the earliest, which again is probably a little bit tight. Is going to be a problem because that's after the due date for all of those entities that were in existence at the end of 23. So again, most people are suggesting that entities should continue working toward getting the data together. They can wait for a little while at least in submitting the data because they might not need to. But I wouldn't stop working out the fact you may have to comply with this rule. As it currently stands right now, it's probable that you will. And I think the reason why I might say it's probable is this isn't a case that's going to be left at the district court. That's, I think, the reason they didn't ask for a national ruling. They didn't want a case starting out in their favor. But there's a reasonable chance that the particular place, because National Small Business United, National Association of Small Businesses have members all over the country, that they really had I don't think it is for totally no reason that they brought the case in Alabama, in the Northern District of Alabama, right? I mean, the organization is headquartered in Chicago. Obviously, FinCEN's in D.C., so you could have had, those two would have been the most obvious places to try it. But of course, they picked elsewhere. And since they were the plaintiffs, they got the pick. So we'll have to see if, will the 11th Circuit be in their favor? And they may or may not have picked Alabama partially because of the 11th Circuit. They think the 11th may benefit them. But yeah, it's going to be something to watch. And I think for most of us, we may not know much of anything about whether we will or won't have to do this until and unless the Supreme Court gets involved. So keep that in mind. Next up, we have an IRS news release. It's IRS News Release 2024-72. It came out on March the 15th. It was titled, March 22nd Deadline Approaching to Resolve Incorrect Employee Retention Credit Claims. IRS urges businesses to review questionable claims to avoid future compliance action. What they're telling you is the current voluntary disclosure program, which we'll call the first one, because again, there is a reasonable likelihood from what the IRS has done in the past that they will come up with a second, less generous voluntary disclosure program. They're still going to want to offer people the right to come in from the cold if they want to, but they're going to make it less and less favorable the longer you wait. Now, the thing to remember about this program is it offers a significant discount on the amount to be paid to the IRS versus going the route of going through a full IRS exam. What happens in this case is you only have to repay 80% of the credit you were given. So if you were awarded an ERC credit of $1 million, you only had to repay $800,000. You got to keep $200,000. You don't pay any interest. You don't have to return the interest they gave you on your refund. You also don't pay any penalties, right? So advantageous those ways. Now, there are a couple of downsides here, one of which maybe is less of a problem. You do have to provide disclosure of the advisors that worked with the employer. Now, I should say may not be. It may be big when combined with the next problem, because this particular program does not give any protection from criminal prosecution for those who apply to the program. So what's going to happen here is, you come in, you send the money back, you apply for the program, you're going to send the money back, etc., get that 20% discount, no penalties, no interest, and you turn in your advisors who the IRS may contact and who will then give evidence against you, which could turn out to be that the IRS might decide that they have a better case against you than they would against the advisors, because you essentially, pushed the issue, or, you were aware it was not likely good. So there are some problems there that really you need to have some legal counsel before deciding to go into this, because if the IRS were to decide that the employer is a attractive prosecution candidate because a jury would convict. And usually it's because there's a really bad smell case. It's one that has bad facts, or one where it appears that, the people that got paid the ERC credit turned around and simply, went and blew the money on expensive cars, vacations, etc. They went on a splurge. It wasn't used to save the business. And while nothing in the law says that was technically illegal, probably won't go over well with the jury if they believe that your claim was questionable to begin with. So obviously check that. But there are huge benefits to this program if you're not criminally prosecuted. A big if, but if you're not criminally prosecuted. So definitely, if anybody's on the fence about this thing, it's time to say, look, now is the decide, go or don't go, because we're here at this point. The IRS also reminds the employers of a limited time withdrawal program for those who had not received or cashed a refund check. Now, we've had a couple of updates this week. The actual release here doesn't really say, it almost implies that there could be a March 22nd cutoff date for that program as well. The IRS may decide, yeah, March 22nd comes, we're done. We've had some other information this week where the IRS effectively seems to have committed that it will extend sometime beyond March 22nd, but we don't know how far that is. Remember, the withdrawal program only works if you have not yet received or cashed a refund check. So as long as you haven't actually put the money in the bank from your refund, then you can still withdraw when there are different steps of how you go about withdrawing. But you could withdraw your claim. That is a second way out, but it does not work for those who have already cashed the check. Secondly, neither of these programs work if instead of wanting to totally say, nope, for these quarters, we didn't qualify for this program at all, either returning the money or simply withdrawing your claim, you can't go back in later and say, well, okay, we just overclaimed. And really, we should still get, instead of $1 million, we should really have gotten $200,000. Neither program will work to allow you to do that. In that case, you simply have to submit a revised claim. That's how the system would work, okay, based on that issue. Now, the IRS did announce in this news release that they have not yet resumed processing claims received after September 2023 moratorium. I've had a few people ask that, are they processing yet? This goes back and says they still haven't announced when they're going to start processing those claims. So you have to believe that those claims essentially aren't currently being processed. And, we don't know how quickly they'll get there. They also warn us that claims that came before the September date, when they announced the moratorium, continue to be worked, but they are being worked much, much more slowly and will take much longer. That statement is in line with what I've heard from CPAs who have clients with claims that were not paid as of the date they suspended taking new claims, and have found that essentially nothing's going on. I think your clients are probably going to need to be told they're going to need a lot of patience. It doesn't matter how good their claim is. The IRS is skeptical about everything at this point, so it's a problem, right? What's going to happen once March 22nd goes by? That's a lot more interesting. And most likely what's going to happen is the IRS will start issuing more exam notices, I would suspect. They've let people had a chance to come back. I've got to believe we may see a spate of exam notices go out following the end of this week. Now they're going to give you a notice of examination, because previously, if you'd received notice of examination, you could not, you couldn't be part of this program. Now they're going to say, okay, well, we're going to go ahead and maybe send some notices out to people that have received money. Right now, the withdrawal program did still kind of work if you were just under exam, right? But the exam hadn't concluded, but you hadn't been paid in advance. So if they were questioning you about the claim, but had not paid it. So we'll see what happens, but I think the service is likely to start saying, look, we gave you 3 months to come in from the cold. You decided not to do it. You have now rolled the dice, and we're going to see if it comes up the way you'd like it, or whether you essentially blew up everything by waiting. So interesting run to get going on. Next thing, we have a letter demanding the IRS change their ruling on a state tax rebate, 2023 state tax rebate. This is a letter from Representatives Schweikert, Siscomani, and Stanton, all three from Arizona. Representative Schweikert and Siscomani are both Republicans. Representative Stanton is a Democrat. So it is a bipartisan letter. And we're going to find out that we do have both Republicans and Democrats. There is one more player in this game, which brings the number on each party's side to even, all of whom are complaining about this particular IRS ruling. And the problem came down from this follows a lawsuit that was filed by the Arizona State Attorney General, who happens to be a Democrat. So that evens up our political sides in this one, right? So we have those. Now, Representative Schweikert is the chair of the House Ways and Means Oversight Subcommittee. Famously held the hearing on ERC abuse that we had late last fall, where they went over a lot of things, and many of which became part of the bill that's currently stalled in the Senate. So, that's the background. He's been on Ways and Means for quite a while, obviously has seniority, and basically, at least in one sense, seems like somebody who the service will want to at least have a discussion with, even if they're not going to change this position. Now, they're questioning an IRS ruling that certain state payments made in 2023 are taxable, unlike almost identical payments made by other states in 2022. This was with the COVID relief funds, effectively. We have these programs. Some states enacted them as retroactive tax refunds. Some states enacted them as just payments made to residents of the state. And there were various variants of these payments. So now the problem is going to be, are they taxable or not? For 2022, the IRS primarily concluded that if the payment was not a state tax refund, a refund of state taxes, that the payment was going to be non-taxable, either under Section 139, which was for relief from a natural disaster, or under the general welfare exception to taxation. But they never really said which one each program qualified under. Aside from the ones that were tax refunds where they say, okay, we know what those are. But therein comes the game, right? This is the issue. Now, Arizona had passed a rebate system it's an interesting system. I know a bit about it living here. What it was, it went to anybody, kind of anybody. There are certain weird restrictions. You had to, number one, you had to have claimed a credit for a dependent. You had to have been allowed a credit for a dependent on your 2020 return. Okay. And, had allowed a dependent there. And you must have owed at least $1 of tax after credits in 2020, 2021, or 2022. Okay, so this is to get your payment. Now, the state of Arizona was asking the IRS. There was a ruling in August that talked generally about how the 2023 answers might be different. The Arizona Department of Revenue had raised questions with the IRS, asking them about, what's your position going to be on this? Finally, in December of last year, they were orally informed in a video conference with IRS officials that the IRS would consider the Arizona program taxable. But the IRS never put anything in writing until the Attorney General's challenge was filed. Right, the Attorney General Arizona Attorney General protested that this was, it was a wrongly decided issue, etc. So the members of Congress here are complaining about that structure, saying Arizona got it late, it's added confusion and cost people money trying to figure out how to make this work. They also noted the IRS never provided a complete analysis of why most 2022 payments were treated as excluded from income. Again, they were, but again, they never really justified, which, as their complaint is, that made it very difficult for legislatures in 2023 to know what they had to do in order to get a non-taxable treatment, or even if they could. How would that work? Now, most people have assumed that the IRS had tied the COVID-19 emergency to either the exclusion under Section 139, which clearly does have to have some sort of, declared emergency, right? So fine, we had that for COVID. Payments in relief to individuals for relief of expenses that are being incurred due to a national emergency, due to an emergency, they're covered, a disaster they're part of, are allowed to be excluded from income. So that's Section 139. But it's also not totally clear under the general welfare exclusion. If it wasn't the 139 payments for relief from, the impacts of a natural disaster or a disaster, then what makes general welfare exclusions work? And the theory here being is, obviously, when the COVID-19 emergency was ended in May of last year, well, that pretty much, would shut off 139 payments. Although arguably you can still say, well, if they were incurred before, we're just late in getting the money to them. But it still might cover the general welfare exception. Now, the reports I have from some people with the Department of Revenue was that their concern with Arizona was, well, it was outside of the COVID-19 emergency period. Barely, but it was when they passed it. When they finally paid the checks, it was well outside the period. But then number two, they were concerned that people with incomes, let's say as high as $400,000, might very well be getting these payments, while other people who didn't have a tax liability, right, but nevertheless had dependents and incurred expenses, were not getting paid, so they didn't think it looked like a general welfare payment. Now, in any event, we got an interesting mess involved here. And the thing to remember is, if in fact the IRS backs down here, and there have been reports that faced some similar questioning from Colorado representatives, that the IRS did kind of back down and allow Colorado's to be tax-free. It's possible if they do modify Arizona, obviously other states would be writing that have also been told that their payment schemes are taxable. So we'll see what happens here, but keep your eye on it to see if we get anything new off of this for 2023 payments. Finally, this week, we're going to take a look at the case of Foley v. Commissioner. This is from the Second Circuit Court of Appeals, case number 23-1296. It was issued on March 13th of 2024. And the IRS had issued a notice of deficiency in 2018 to the taxpayer, giving them 90 days to file a petition in tax court to challenge the proposed tax. Well, what happened in this case was the taxpayer, who claims now that he never actually got that notice of deficiency, only discovered it via later notices, finally filed a petition 1,393 days after the notice was issued, or 1,303 days after the deadline. So the point is, not surprisingly, the IRS said, we want it out of here. Now, one interesting thing, and this is why this case is here. He had filed the case under the small case procedures under IRC section 7463. Now, that's a simplified method of taking something to trial. The amount of tax, interest, and penalty for a year have to be less than $50,000 for a case to go this route. But if you do so, you get a much more simplified method in court, much more informal method. However, one of the downsides of this, because again, you don't have to go this route, is going to find this issue. Now, the IRS, the tax court dismissed the case, finding the petition was not timely filed. But what we have here in this section is the part of 7463B entitled Finality of Decisions. It says a decision entered in any case in which the proceedings are conducted under this section, the small case procedures, shall not be reviewed in any other court and shall not be treated as precedent for any other case. The not be reviewed by any other court is the problem here. Right? 7463 says whatever decision the tax court renders, that's it, that's final. If you want to have the right to appeal the decision, You need to go through the much more formal standard case rules, right? And get at least a tax court memorandum decision out of the group to move forward and go to your Court of Appeals. But the taxpayer did not do that in this case. Now, the taxpayer still filed their petition with the Second Circuit Notice of Appeals, challenging the dismissal. They argued that the fact that the tax court said, sorry, I can't take this. I don't accept your filing. We're going to throw it out. They're saying, well, really, we never had a decision because, the tax court never actually ruled on our matter. And so as such, we want you to rule that they need to take this petition, and then they could hold their hearing. And we'll agree that we cannot come back to you if after the hearing, they say, you know what, they owe the tax. But I should be able, the theory is, to at least get my day in tax court with a small claim. Now, the IRS had argued, of course, that per the plain language of 7463, the Court of Appeals had no jurisdiction to review the tax court's decision. Right? And they're saying, that's it. He chose this. He checked the box to say, go with the small case procedures. It's like, he made his choice. He's got to live with his choice. The court basically agreed. They found that this was a decision, because that's the key. Remember, a court cannot review the decision in a decision in this case. The question would be, was the dismissal of the case for failing to file the petition timely, was that a decision of the court? And the Second Circuit decided the answer to that one was yes, it was. Now, interesting enough, the panel avoided dealing with the circuit split we currently have on whether a 90-day filing rule is jurisdictional. Now, I think it's a little bit, shall we say, let's say generous to the tax court to say the circuit split. I think the reality of the day is we have a circuit that says clearly you can go to the court, and if you have good enough cause, get the 90 days waived so you can have equitable relief. The tax court does not agree that covers deficiencies. The Supreme Court had ruled it covered collection due process hearings, but they didn't actually deal with a deficiency case. And so the tax court has taken the position, even following the case in the Third Circuit, called via commissioner, that found that, in fact, this was not a jurisdictional only problem, but it was one where you'd have to consider having some sort of, if there was reasonable cause for the late filing, then you could grant equitable relief and let it in, right? The tax court has already said now in a follow-up hearing, I should say, that, no. We're not following this outside of the Third Circuit, right? Because that's it. We're not going to follow it anywhere else. We're saying there. Now, Mr. Foley was outside the Third Circuit. He's in the Second Circuit. So basically, tough luck. You can't argue for this relief. Now, there is an older case from the Seventh Circuit, the Tilden case in 2017, which did hold that this was considered to be, basically, it is jurisdictional. And the only problem with that is the Supreme Court came down with that CDP case that had similar language in the statute and said, no, you have to offer equitable relief with this language. And obviously, Culp has decided that ruling effectively overturned prior rulings. And we haven't yet had a case go back to the Seventh Circuit or any of the other circuits that have gone along with this jurisdictional principle and had them overturn their prior decisions. So we're not too sure. But what the court said was the taxpayer position inherently argued the decision was jurisdictional, not based on the merits of the case. And since they decided it was jurisdictional, and I guess how the Second Circuit effectively decided this was that, well, if you tell me they decided on the merits, then that's clearly a decision and we can't review decisions. But if you tell me that it was jurisdictional, then, you don't really have, you're not appealing the right thing, right? We can't look at this other information, but it has to be jurisdictional or you're, oh man, it was such a horrible thing. I didn't get it. The IRS didn't send it to me, etc. That is all going to be equitable relief but you've already told me that apparently this case shouldn't qualify for equitable relief. So at the end of the day, they didn't. Now, as I said, this is something to remember. Anytime a taxpayer decides to go to small case procedures, you are limiting yourself entirely to the tax court. And again, whatever they decide, this particular case tells us essentially that if they decide to throw your case out for whatever problem, that, yeah, you're going to have no recourse for that either. There's no out on this. There's no way around it. And there's no way to refile this case, it would appear, even if the Supreme Court were to come down and, let's say, take a case and decide, yeah, we mean this generally. The 90-day letter rules are always, can always be overridden by equitable relief granted by the court. They haven't said that, but that would be the issue. Well, this has been the current federal tax developments for the week of March the 18th, 2024. You are now past the pass-through entity due dates for returns. Hope that went well for you. We now have less than a month until the 1040 deadlines come. So, time's flying, guys. All the fun's happening now. So we'll look forward to that. If you have any questions, you can find me, Ed Zollers, at currentfederaltaxdevelopments.com. I also do post on the Connect sites for Arizona, New Jersey, Minnesota, Illinois, Washington, and now Idaho's shown up. They switched over to Connect, so technically it's Connect site there now too. So if you have any questions, you're a member of one of those organizations, you go ahead and post there. Otherwise, we'll see you back next week. We'll talk about whatever else might come up here in the area of federal taxes.